Welcome to the 14th Regulators and Policymakers Retreat being organized by EPI here in Goa. We're at the EPI studio, and I would like to introduce our guest for this afternoon, Mr. Vikas Singh, former Solicitor General of India. Welcome to the retreat and to the studio, Mr. Vikas Singh, sir. So, we'd like to know, there is a particular piece of legislation that is called the Electricity Act 2003, which is the overarching act which governs policies, regulations in the electricity sector. What are the 3 or 4 key aspects in the act, sir, which make it consumer friendly, which make it power market reform friendly, that we can explain to viewers?
Well, if you want me to explain in layman's terms, the 2-3 features which are very new in this act are firstly completely freeing generation from any licensing requirements. So the whole idea was to bring in private sector into generation of electricity without having the obligation of taking a license. So generation of electricity is completely free. And the second most innovative feature is open access. Open access means that if you are a consumer, a large consumer of electricity, and there is a particular distribution company which is supplying electricity to you, and if for any reason, whether it be tariff or any other reason, you are not happy with your own distribution company, you can buy power from anybody and use the assets of the distribution company to bring power to your unit. So these are 2 very important features of the new Electricity Act. Apart from the fact that this is one act instead of 3 or 4 that we were having prior to this act. So all aspects of electricity generation, transmission and distribution have been brought into one act by this consolidated act of 2003.
What would be your 2 or 3 wish list suggestions for amendments in the Electricity Act to make it more relevant and pertinent to today's scenario?
Well, if you ask me, this act, according to me, is not very well drafted. It's actually a gold mine for lawyers like us, because there is so much of interpretation that you can bring in to suit your client's perspective. So according to me, this act needs to be again looked into more closely. And one of the features which I feel definitely needs to be brought in is that the act should provide some guidelines even for the competitive bidding process. It's been left to the central government to decide the guidelines, but the guidelines that the central government has framed so far completely lacks vision. So if the act were to give some vision by providing what kind of guidelines the central government were to provide, I think that will go a very long way in addressing the problems of the generators, of the consumers, of the overall electricity shortage in this country. So it will be a very big thing which is the need of the hour.
So when it comes to litigation, certain states, when they are denying generators open access, or maybe even denying consumers open access, I'm not sure there is such a case, they approach the High Court where they feel that submitting something in the High Court will delay things further, will give them a breather, a longer time, many more months than it would have if they had submitted it to the regular court, for example, Appellate Tribunal, which is a special court for electricity. Do you hold that this view is correct?
No, the reason why people are going to the High Court is not because they want to delay. The reason why they go to the High Court is because the Supreme Court in the constitution-made judgment of Power Trading Corporation, which I had the occasion to also argue, has taken a view that if there is a regulation by a regulator, that can't be challenged in the appellate tribunal, that has to be challenged in the High Court, which according to me, if you ask my view, is definitely not correct. If a regulation, this is not a legislative regulation in that sense, this is more of an administrative regulation. And if the regulation is made by a regulator, the appellate tribunal, which has also people expert in the field, should definitely have a relook at the regulation. But because of this judgment of the Supreme Court, which bars the appellate tribunal from looking into a regulation, now people are forced to go to the High Court. So probably at some stage, when judicial thinking gets a little more evolved, probably at some stage this PTC judgment will have to be overruled. And these regulations will not be looked as a regulation or a rule which is framed by the central government in exercise of its legislative powers. This will be looked more like a administrative decision-making process.
Right.
And in that sense amenable to the apparent factor.
Looking at recent cases in the power sector, sir, the certain star cases, so to say, would be the case of Adani and Tata Power, where they had bid for a certain tariff, and because their coal prices went up, they had to come back to the regulator or to the government and say that our coal prices have gone up, so please give us a tariff revision. The tariff revision has in fact, in a way, come through. But what implications does this have for a sanctity of contract and the essential, the Indian Contracts Act? How sanctimonious is that particular act?
Well, as far as the Adani judgment is concerned, I look at it not merely as an adjudication of a dispute between a prospective generator or a generator and a distribution company, but more as a problem which the nation is facing as far as having some kind of certainty to a generator is concerned. Now we are actually looking at development of infrastructure. When we talk of Adani as a bidder, in a sense he is a partner to the development of the infrastructure. According to me, Adani made a huge mistake by giving such kind of tariff where it could have asked for a fuel pass-through. It didn't ask for a fuel pass-through. And because of that mistake, the tariff is being sought to be revised. It's their own mistake. They have no reason in normal contractual situations for them to have any recourse. But what we have to appreciate is that these are very, very large investments. And if these investments, and about 2/3 price is the fuel price in the generation of electricity. Now, if you don't provide for this pass-through of fuel, what is going to happen? It's not as if a 1,000 crore industry will lose a 10 crore and still do business with regard to its 990 crore. Here is a case where if the business model doesn't remain viable, the industry has to shut down or it becomes sick. Now, if it becomes sick, then who ultimately accounts for the problem? Ultimately, the taxpayers' money only goes into concessions, interest rate reductions, and all kinds of reliefs that the Sick Industry Companies, Sick Industrial Companies Act provides, the SICA Act provides. So basically, you are looking at a situation where your partner in development of infrastructure has become foolish. Now what to do? You have to bail him out, because ultimately it will not be in national interest for the entire investment to be stranded and to be of no national utilization. So that's why I said that the competitive bidding guidelines actually are completely, it may be technically very sound. The guideline may have all the technical details which you are required to do for the purpose of making a bid, but the guidelines completely lack vision. They could have had a cap, lower cap, an upper cap. They could have asked that even if you do a bid like this, case one bid, still you will have to give your breakdown or breakup of what is towards fuel, what is towards capital expenditure, what is towards interest carrying costs, etc. and etc. If that had been there in the bid itself, at least the regulator would know that only this part is affected.
Right.
And to that extent compensate him in some manner. But what the regulator ultimately has done is actually completely rewritten the contract, which according to me they could not have done.
So why, in your opinion, is the case one bidding process not happening when we are in such a dire need of generation?
Because of the same reason that the guidelines are completely without vision and without foresight. If the guidelines had been properly drafted, a lot of case one bid would have come and people would be ready to invest, because they would know that these eventualities are taken care of. But case one bid is so open-ended, and when a new sector comes in this country, especially when it opens to the private sector, there is a rush to invest in that sector and to actually take the advantage of the initial spoils. In the process, that aggressive bidding takes place, which can go the Adani or the Tata way when it happens.
What would be your suggestion, sir, to ensure that we have a well-drafted piece of legislation and a well-drafted set of laws and competitive bidding guidelines?
Well, firstly, I would say that there are two ways of dealing with it. One is that the guideline itself should be such that it provides for a model PPA, which ultimately will ensure that all these or most of these factors are taken into account. The second stage would be that every regulator should have regulations in place which will have the authority to look into these PPAs in cases of certain unforeseen circumstances. Now what is happening today, when the CRC judgment came, they didn't have any regulation. They have decided without any regulation. they have interfered in a concluded contract without there being any regulation in place. Whereas Supreme Court in the PTC judgment says that you can make inroads into a concluded contract only if you have regulation. So the second stage should be that every regulator should have regulations, and those regulations should empower the regulator in extreme circumstances to look into certain aspects of the PPA which have made it unworkable because of change in. It may not be a force majeure in the technical sense. It may be a business, a wrong business decision taken by a generator. But when you look at the generator as a partner in nation building, as a partner in creation of infrastructure, then you have to have some means of resolving the problem that he has faced after the bid has been done by him.
So the one issue that has been discussed in the power sector is when a bidder comes to the bidding table and he puts in certain bid parameters and figures, then people who have lost out on the bid say that we could have bid better and gotten this particular contract. So it is really unfair on part of the original bidder to have stepped into the door, put in like a salesman, gotten it at some bidding parameter, and then change the had the parameters changed later on.
I 100% agree with you. That's exactly what has happened in this case. Now, for instance, when Adani or Tata took this bid and went for this power plant, there could have been a more conservative bidder who probably factored all these problems or these eventualities, or who factored in that there could be certain changes which are likely to come. But he lost out because his bid was not the lowest. Now, that's why I say in a lot of industries there is a concept of having a bid which will be workable, and below a particular rate they say it will not be workable. So if you have a system like that in place, probably Adani and Tata may have been rejected because that bid would have been held to be unworkable.
A ceiling and floor mechanism, like
a ceiling floor mechanism, both up and low ceiling. Now you take the case of Noida Power. Noida Power, through the bidding process, brought in SR at 4 rupees some paisa. 6 bidders were there. Noida Power was the lowest at 4 rupees something. While the matter is with the commission to approve that bid, somebody comes in with 3 rupees 60 paisa, Athena Power, and the distribution company is willing to negotiate. Now, if there is somebody willing to provide electricity at 3 rupees 60 paisa as against 4 rupees something which SR has bid, then definitely there is something wrong in the bidding process, because somebody has definitely tried to make a fast buck in the bidding process. Now, because of the lack of guidelines, because of the lack of cap upper and lower, this bid goes straight away as a pass through to the regulator to approve. But if there had been, supposing a range of say 3 rupees to 350 as a viable range, then anybody above 350 would be forced to negotiate, and the regulator or the DISCOM would have the authority to negotiate. But because of this vision not being there in the bid documents, all these problems are coming up.
So looking at the coal sector, we badly need our own coal to generate power. What do you think can break this impasse in the coal sector right now, that coal is mined and power producers get enough coal?
Well, that's a very complex problem. Unfortunately, the coal allocation itself is in so much of controversy today. And if you ask me, these coal allocations definitely should have very well structured back-to-back agreements, where a coal person who gets a coal block should be having the obligation to generate power, and if the generation doesn't come within a time frame, then the coal block allocation should go. I mean, that's the only way you could ensure, and that's the only way you could also ensure that generation of power is at a price which is affordable. But unfortunately, that's not there. Coal blocks are being given for persons to persons who may not be genuinely interested in generation, and some of the coal blocks have actually, in fact, traded on the coal like the blocks that they have. So that's a complex problem which probably the government will have to resolve. And if the government is not forthcoming, then probably the courts will have to step in and do something about it.
Is it possible for one particular sector, like for example the coal sector, to look at another sector, like for example the oil and gas sector, where we already have a model production sharing contract, and we have a very established set of way of sharing the spoils of what you receive from the ground, which has now been declared as a national resource? Can we look at cross-sectoral issues and learn from that?
Actually, I'm very critical of even the gas allocation policy. I don't know whether you're aware, even in the gas allocation, I had the privilege of arguing on behalf of the power producers, gas-based power producers, the High Court of Andhra Pradesh. Gas is not being supplied to the power plant. I don't know whether you're aware. Power plants, gas-based power plants are getting hardly 20% of their PLF supply of gas. And West Coast has a terminal to import LNG. And these power plants are all situated in the East Coast where there is no terminal today.
Right.
So if you were to import in the West Coast and transport it to the East Coast, the cost at which gas would land at the East Coast would be completely prohibitive.
Right.
Whereas what is happening that the Reliance gas, which is at Godavari Basin, is being all transported to the West Coast and to North India to supply to these fertilizer plants, and the power plants which are there right there at the site are being neglected. I mean, it's a very, very faulty policy where they are looking at fertilizer generation without realizing that a fertilizer production of fertilizer is meaningless if the agriculturist doesn't have power.
Right.
So how does he utilize the fertilizer meaningfully in agricultural generation? So that's a very, very again flawed policy. But as far as this coal and gas being interlinked in some sense to look at the availability of fuel for the power sector, I'm sure you're absolutely right that there should be a mechanism by which there should be one policy with regard to power generation, and fuel for power, whether it be coal or whether it be gas, could be sourced under that one policy.
Yes, sir. My question really related to an upstream policy rather than downstream policy of allocation. What I meant here was foreign majors and people who have the capital and the technology for better mining of coal. One of the figures that was given that Coal India is mining at 1/4 the efficiency of the international benchmark. Similarly, in oil and gas, we are not having international oil majors really come and start exploration, even though there have been NELP rounds of the past 5-6 years. So, sir, what can we do to ensure that foreign investors can get a reasonable rate of return on capital, something that their stakeholders will be happy with, and Indian stakeholders will also be happy at with the prices that we receive?
No, firstly, for that, the government will have to have the policy of permitting foreign companies to mine coal in India, which I don't think is not there at the moment. It's more of a monopolistic kind of a business which Coal India is having. And ultimately, if you ask me, in the long run, this will have to be by privatizing Coal India itself. And that will be the right way, because if you privatize Coal India, then you will get the best of the people in the business to come and take over Coal India. Maybe not privatize the whole thing at one go, but maybe privatize the various coal mines one by one, and government will earn huge amount of revenue, and the inefficiency which is there in the coal mining sector by virtue of the public sector doing the mining will definitely come down. I sincerely feel that there are a large number of activities where government should not be involved in, and coal mining is definitely one of them. Hotel business is the other, airlines is the third. These are activities where definitely the government should not be there. Government's job should be only to ensure that there is proper infrastructure, there is proper education, human resource development, there is proper law and order. The rest, they should permit the industry to take over and optimize the natural resources that we have in the country.
So, looking at the land acquisition bill, taking this further for industry, do you think this is a well-drafted bill, and does it have enough clauses and technical?
To be honest, I have not gone through the new bill of acquisition.
So, your vision for the growth of the power sector, so that litigation is reduced and we have more development?
Well, there can't be any way by which you can reduce litigation. Probably you can only reduce litigation by bringing in a better piece of legislation, which is the Electricity Act. Revamp the whole Electricity Act and bring in a better piece of legislation. But as far as the growth of the power sector is concerned, I feel that there should be a interministerial approach of ensuring that the power sector remains a healthy industry in this country. What is happening is gas is not being supplied because Petroleum Ministry feels that it should go to the fertilizer industry. Coal is not being supplied because coal is under a different ministry and it has its own compulsions and its own limitations of dealing with coal. So if you have one central notified authority to deal with the power sector as a whole, which will have access to the other issues of power, which is fuel, mainly fuel, then probably only there can be a viable solution to long-term development of the power sector.
For example, a unified Ministry of Energy with coal, gas, power under
Energy will have coal, gas, power all together.
Right.
That would be one way out.
Thank you, Mr. Vikas Singh, sir. Wonderful having you at the retreat, and I hope you enjoy it.
Thank you. Thank you.